So how do we mitigate the risk and the time it takes to recover a debt? And the most important thing is the documentation that you collect from your customer upfront when starting the relationship. Um, in terms of any court process, whether you follow action procedure or application procedure, the burden of proof is on the claimant. So if you make an allegation, you must prove that allegation. So in this situation, you would say, I'm owed 100,000 Rand because I've either delivered goods to the value of 100,000 Rand or I've rendered services to the value of 100,000 Rand. You have to have all the documentation in place to show that you can prove that the goods were delivered or that the services were rendered and that you have not been paid. So documentation is crucial in proving the claim and even in the execution of a judgment, because the more detail you have about your customer, the easier the execution process is. It's also important to note that there are many issues that can be resolved upfront in order to curtail the litigation process and deal with the issue of cost. So, for example, like I said previously, you can agree with your customer upfront that in the event of non-payment, that the debtor will pay legal costs on a higher scale. And the higher scale we have is what's called the attorney and own client scale. And this allows you then at the end of a trial or at the end of the litigation process, not to be limited by court's tariff, but to actually recover based on the rates that your legal representatives are charging. It's also then at this stage it can be agreed upon to charge your customer a higher interest rate than that is typically allowed. If no interest rate is agreed upon, the prescribed rate of interest would apply, which is currently 11%. So if, for example, you include a clause in your agreement or in terms and conditions, you can say you would use the normal rate plus 2 or plus 3%, which is then quite a healthy rate. So that kind of provides some cushion for the time it takes to recover your debt. At least the debt is incurring interest over that period. Okay, so the terms and conditions are important to set basically what the rules of the game. Like I said, it allows you to stipulate what scale of cost you can recover if you have to sue for your debt. It allows you to set the interest rate. It allows you even to decide or pick which jurisdiction or which court you will be in, so that you can also reduce your time and cost. So, for example, if instead of going to the High Court, you can agree with your customer that even though your debt falls outside of the jurisdiction of the magistrate's court, that both of you will submit to the magistrate's court, which can at times make the process a little bit cheaper and faster, although not always the case. The second thing about terms and conditions and the Consumer Protection Act tries to stress the importance of the use of plain English when drafting these documents. And I'm guilty of it myself, is when you're drafting terms and conditions, it's always everybody falls into the trap of trying to use the biggest words and most technical phrases, but it's not always to your benefit. And if it if you don't understand what your terms and conditions say, it's the chances are that your customer won't understand them either. So there's no downside to using plain English and simple terms and words to make sure that you understand your terms and conditions, your staff understand it, they know how to use it, apply it, they know what's important, what's not important. and then be able to explain it to the customer so that he also understands that, for example, if you do not pay your debt, you will be taken to court, you will be charged costs at a higher rate, you will pay interest, and try and discourage them from not paying their debts and making sure they understand when payment is due. But the more important thing about terms and conditions is it's an opportunity, and it's an opportunity to collect as much documentation and information about your customer right at the beginning. It allows you to request from them details. What is their, for example, if we're dealing with a company, what is your registered name? What is your registration number? Where are your premises? Where's your registered address? You can even go so far as to request their banking details, because it must be remembered that a bank account can be executed against. So, for example, if you know where your customer banks, once you obtain your judgment, you could send the sheriff to that bank and obtain payment directly from the bank if there are funds there. So it's always important to make sure that you collect as much information about your customer, which then reduces the time of locating the customer when you need to initiate the court process, and it reduces the time of locating assets when a judgment is obtained. Now, the last point there is KYC, which essentially is the acronym for Know Your Client. Now, I'm sure everybody will have heard the term KYC when going to a bank or to an attorney or something like that. Now, banks, attorneys, car dealerships, accountants, all of us, we're forced to collect certain information about our clients before we're allowed to provide goods, services, or sell goods to those customers. And that's required by the Financial Intelligence Act. Now, I remember when this started, I thought this was a bad thing, that's something that would cost us time and resources. But it's actually had the opposite effect for us, as it places the obligation on us to collect sufficient information from our clients before we do any work. It forces us to conclude agreements with clients up front, and that is something that everybody should be doing. You should be having a written contract with each and every one of your customers, and it doesn't have to be a long technical thing. Like I said, it can be a short one-page agreement, but it's about knowing who your customer is before you provide services and before you sell products to them. As also mentioned, it's also important to know what type of entity you're dealing with. Is your customer an individual? Is it a CC? Is it a Pty Limited? Is it a joint venture? What is the name of the customer, the registration number? There's differences between a trading address and a registered address. And also beware of trading names. In the past, we had it more regularly, where you would see a company by the name of ABC Pty Limited, and they're trading as XYZ, for example. I don't think that happens as much these days, but if, for example, you know your customer is XYZ and you search them on the CIPC database, nothing will come up because it's a trading name. The actual registered name of a company is the name you need, otherwise you cannot locate that company. So it's of crucial importance to know the correct details of your customer and to collect it up front, and even to verify it, if possible, to make sure that the information they're giving you is accurate and correct. And this, like I said, should be done in every business and just requires a little bit of effort up front, but it makes the back end of things so much simpler in the event that you're not paid for goods sold or for services rendered. Then the other thing that can be done in terms and conditions or in an agreement is to include security for your debts, and this helps to mitigate your risk. And the most standard way of doing that is to include a suretyship in your document. Now, for those who don't know, suretyship is essentially it's a legal agreement where a third party promises to fulfill the debt or obligation of another party to yourself in this instance. So, for example, if you're supplying goods to a company that's newly registered, doesn't really have a credit rating or has a bad credit rating, you can ask the directors to stand surety for that debt. Now, I know most directors or shareholders and things like that, they will be very reluctant to do that. But then it comes to the point where you have to say to the customer, we simply cannot deliver goods, or we cannot render services to you unless you agree to sign a surety. And at the end of the day, there's no point. A lot of people will say, you don't want to upset your customer, but there's also no point in rendering services or delivering goods if there's a good chance you're not going to get paid for those services or goods. So if problem arises, it's a good opportunity to say to a client, you need to now sign a surety before I continue with my services or before I deliver my goods. The second option is what's called the cession of book debt. And this is a legal agreement where the customer transfers their right to collect money owed by their customer to you as security. So it's quite a complicated situation, but it basically means if you deliver goods to B and then B sells it on to C, you can claim your payment from C directly, which, especially where C is of a better financial footing, it just gives you that opportunity where instead of having just to rely on the ability of your direct customer to pay, you can go and collect payment from their customer, which gives you at least a better chance of success. And then the third option for security is what's called a guarantee for payment, which essentially is the promise to pay. But it's one that cannot be withdrawn. It has very limited defenses to it. So it just creates a better opportunity for you to obtain a judgment against the creditor or against the debtor, either by default or by summary judgment if you get that far. And then another point to consider, and this is obviously not applicable to most companies, but with the VAT increase that's been announced recently, if your agreements stipulate a specific VAT rate, like for example 15%, then those contracts have to be amended to cater for the VAT increase. Otherwise, you could be liable for the difference. Most contracts would always say the price is 100,000 Rand plus VAT. But if your contract, for example, says 100,000 Rand plus 15% VAT, then you need to have a look at those documents and make sure that they are up to date. Then the National Credit Act, what does that entail and why is it important for debt collection? Essentially, it's important because it affords the debtor the right to submit himself or herself to debt counseling and places additional obligations on a supplier to do investigations before affording a customer credit facilities. But what's more important about the NCA is that it includes incidental credit as part of its definition of credit. And this simply put means that if a debtor owes you money, even for one day, it amounts to incidental credit and is therefore governed by the National Credit Act. And this is important when a customer pays you an invoice or statement and they fail to pay you on time. So, for example, if your customer is paying you on 30 days from date of statement and they fail to pay you on day 31, it can be viewed as incidental credit. And though you never intended to give your customer credit, all of a sudden it's now considered credit. So this then places the obligation that once or prior to issuing of a summons, a claimant is required to send a notice in terms of Section 129 of the Act, and basically affords the debtor the opportunity to submit him or herself to debt counseling. However, the National Credit Act does not apply to large customers, large companies, whose annual turnover exceeds 1 million rand or whose asset value exceeds 1 million rand. Thus, most companies are typically excluded from the protection of the National Credit Act. And furthermore, the National Credit Act does not apply to large agreements exceeding 400,000 rand in value. And then you can also escape the clutches of the National Credit Act if you fall within the definition of incidental credit, where no interest, credit fees, or charges are levied on the customer. Okay, then as previously mentioned, the prescribed rate of interest is applicable to all debts where no rate was agreed upon, and it currently sits at 11%, which is still quite a healthy rate in this day and age. The NCA has its own credit or interest limits for unsecured credit, which is typically higher than the 11%, but it's just not desirable because it then can bring you within the application of the Act. And then agreed interest rates can be agreed upon in the terms and conditions, which are higher. And also the legal costs that I mentioned before can be agreed on a higher tariff. Okay, then the other concern is what's called prescription. Prescription is that a debt is extinguished after a period of time, which is 3 years in South Africa. So therefore, if you haven't issued a summons or received an acknowledgement of debt, after a period of 3 years, your ability to recover that debt is extinguished and that debt's no longer valid. So it's another concern and point just to have in mind that you have to act quickly once a customer doesn't pay, and it's always a difficult decision to make. Do you sue your own customer? But at the end of the day, if you wait too long, the longer you wait, it makes it more difficult to in my mind to prove your debt and to recover your debt in execution. But if you wait in excess of 3 years, you simply cannot proceed with that claim. However, the application of prescription can be excluded in terms and conditions, which is just another thing to look for and to add. Another thing that you can cater for in terms and conditions and agreements is for alternative dispute resolution. And that's where your dispute is referred to arbitration, mediation, or adjudication by agreement. And it basically just replaces the court with a private court, so to speak, where you appoint your own arbitrator, your own mediator, or your own adjudicator, but the costs of that process are then footed by the parties instead of by the state, because obviously the state pays for the court or access to the court. The problem with this process is it requires an agreement to arbitrate, and it can only be used where there's a dispute. So it's not really available for debt collection where the customer is unable to pay its debt. It only applies where customer disputes the debt, either due to poor workmanship or defective products. And obviously, like I mentioned, with mandatory mediation being implemented in the high courts, this could become a step that is forced on the parties, whether they agree to it or not. And then lastly is what I just wanted to touch on is the debt collection in the African continent. Obviously, it happens, I think, more and more where services and goods are supplied cross-border. And these debts, although it can be a bit more difficult or different to collect because of differing legal systems, it's still possible to recover a debt. But one way to cater for these issues of differing legal systems is simply just to provide for an arbitration clause in your contracts, because South Africa is part of an international arbitration treaty which allows for an arbitration to be held in South Africa, judgment to be obtained, and then to enforce that judgment anywhere in the world. So it's always something to consider, that if you're providing services in cross-border, that you cover yourself to provide for jurisdiction in South Africa and submit to arbitration, which just makes it a little bit simpler to enforce the debt. But the problems always occur with the differing legal systems, and typically we find that when we are instituting actions in other countries, that the fees are charged in US dollars rather than in rands, so that can make it a bit more expensive. Okay, so that's basically all.